fill in the blanks. What constitutional right? Prove that you have the constitutional right. Tell them the state doesn't have a right to convert that right into a privilege. Tell them that they can't even punish you if they do. And then claim that the prosecutor can't prove willfulness, so you obviously didn't do no crime, and then flip around and demand for your dismissal, which is your right, and get your costs and fees for having to defend this frivolous case. May it please the court. And I promise you, you will be amazed. 40 attorneys will jump up and say, yeah. They'll come up and shake your hand and tell you that's one of the most magnificent arguments they've ever heard. They'll tell you got something like King Kong for taking on the Bar Association or whatever. Now, I'm telling you these things have personally happened to me. I can relate the exact cases. That goes for practicing law without a license. Obviously, you got a right to work. You got a right to contract your right to work as you see fit, not as some arbitrary and capricious Bar Association sees fit. Right? Doesn't that make sense to you? You don't want to belong to the union, that's your right. This is a right to work state, right? The bottom line is this. They cannot compel you to have a license or pay a fee for the exercise of your right. And if they do, you can ignore the license and a fee and engage in the right with impunity. That means they can't punish you. And since you got a perfect defense to the element of willfulness, they cannot punish you. They have to dismiss. They do not have a cause of action. Now, this argument I'm telling you is taken us over 18 years to develop in courts and in law libraries over the years, and just kind of compiling and arguing cases and doing this. This argument is a killer argument. Have they ever won against us on this argument? Nor could they in the United States of America as long as the Constitution stands. I'm asking that you pay attention to this argument and start utilizing it. We'll show you some of the techniques later in the second half, alright? Now, the word willfully has the same meaning, alright? In controlling the voluntary, intentional violation of a known legal duty. And the distinction between the statute is found in the additional misconduct that is essential to the violation of the felony provision. If they can't prove willfulness, they can't prove nada. Okay? Has everybody got that? Now, let's go to the next one. Now that you've won and your rights have been violated, the next thing they will claim, well, we acted in good faith, or well, we acted in good faith. We had good faith reliance that you broke the law. Okay? And that means you can't sue us. That's a lie. You see, since these two cases, Owen versus City of Independence, which is recorded at 100 volume, and you want to look at Supreme Court reports. Now, that's a different reporter. Supreme Court reports will actually say on the back of the reporter, Supreme Court reports. It won't say U.S., it'll say Supreme Court reports. So that's a different volume. It's a newer reporter. So you want the 100th volume, and you want to look up Supreme Court reports, and you want to turn to page 1398. There is also a counterpart case to this Owen case, which is Maine versus Thibodeau. I'll give you the site for those. Okay, I gave you Owen versus City of Independence, so I'll give you Maine versus Thibodeau. Maine versus Thibodeau is recorded at 100 Supreme Court. That's 100th volume. Supreme Court Reports, page 2502. Now, basically, the summation of what these basic arguments say. Where plain language of a statute supported by consistent judicial interpretation is strong, it is not necessary to look beyond the words of the statute, right? Now, these are both civil rights cases. The right of action created by statute relating to deprivation under color of law, of state law, of a right secured by the Constitution and the laws of the United States encompasses claims which are based solely on statutory violations of federal law and apply to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Now, whenever this happens, folks, you must understand something. And that goes for both Maine versus Thibodeau and Owen versus City of Independence. And I'll tell you the brief synopsis on both these cases. Owen was a police chief in the town of Independence, Missouri. And he got in a gripe with the city council, and they indiscriminately fired him without just cause. Owen turned around and sued. They claimed that they acted in good faith. The Supreme Court said, "Sir, you are deemed to be officers of the law. You are to advise us to the law. You can hardly claim that you acted in good faith for a willful deprivation of the law, and you certainly can't claim ignorance of the law, because a citizen out here on the street can't claim ignorance of the law, and it makes the law look stupid if an officer of the court or some officer of government doesn't know the law, and then they go ahead and abuse somebody's constitutional rights. So in matters of constitutional rights, both these cases uphold one point. And the point they uphold is that whenever they violate your constitutional rights, they do so at their own peril. And it even says that in Title 18 United States Code Section 241 and 242. It says that upon conviction you are subject to a $10,000 fine, 10 years in jail, or both, and if death results, life in prison. They're telling you, don't violate somebody's rights. Please, don't do that. Title 42 United States Code Sections 1983, 1985, and 1986 clearly establish your right to sue anybody that does that. Now, they're going to claim you can't sue them because they have judicial immunity. Well, guess what? These two cases remove judicial immunity. There is no judicial immunity for violating somebody's constitutional rights. Judge, you are deemed to know the law and sworn to uphold it. You can hardly claim that you acted in good faith for willful deprivation of the law, and you certainly can't plead ignorance of the law, for that would make the law look stupid for a knowledgeable judge to claim ignorance of the law when a citizen on the street can't claim ignorance of the law. Therefore, there is no judicial immunity. I want to get that across. I don't know how many attorneys come up to me all the time telling me, well, they're immune because they acted in good faith. They're just not reading their court. They're not reading their court reports, because if they were reading their court reports, they would have known this case has been on the books since 1982. Both these cases came down in 1982. So I want you to pay attention to these cases. When somebody tells you they can violate your rights with impunity, you just kind of smile and say, make my day. Okay? Now, the next case we want to talk about is Briers versus United States. We mentioned it previously earlier. Briers is recorded at 273, volume 273, U.S. Reports, page 28. Okay? Now, Briers versus United States is a unique case. It's a search and seizure case, but basically it sets constitutional standards which we had talked about in the am jurisprudence sections. Okay? I especially want to pay attention to note number 3 here. Constitutional provisions for the security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachment therein. All right? When a federal officer participates officially with a state official in a search, so that in substance and effect it is their joint operation, the legality of the search and the use and evidence of the things seized is to be tested in federal prosecutions, as it would be if the undertaking were exclusively the federal agent. All right? The reality here is what they are setting is the standards must be liberally construed in favor of the citizen. It's the duty of the court to make sure that happens. So now you have a right to be wrong. You have a right to enter your viable defenses that you honestly think. No state can convert that right into a privilege and issue a license and a fee. If they do, you can ignore the license and the fee. They must prove the burden of proof of willfulness, which they cannot do. If they do violate your rights, you do have a right to sue them in Owens v. City of Independence and Maine v. Thibodeau. They have to give every consideration to you, all right? And that's the way it is. 1900 yesterday, all right? The next case we want to talk about is Boyd. Boyd v. United States is recorded at 116, volume 116, United States Reports, page 616. So everybody got that? Can you see? Bear with us, folks. We're really trying to jam here for you. Boyd versus United States, 116 U.S., page 616. The court is to protect against encroachment of constitutionality or secured liberty. All right? Now, it is equivalent to a compulsory production of papers to make the non-production of them a confession of the allegations, which is pretended they will prove. And a lot of times that happens in federal cases. They'll claim something, they won't prove it. That's happened to me, believe me. And then the fact that they've claimed it makes it true. All right? Now this, excuse me. And then, of course, you have to prove a negative, which is impossible. All right? Now, the seizure or compulsory production of a man's private papers to be used in evidence against him is equivalent to compelling him to be a witness against himself in violation of the Fifth Amendment, and in a prosecution for a crime, penalty, or forfeiture is equally within the prohibition of the Fifth Amendment. See that? Now, the bottom line here is Boyd protects against encroachment of constitutionally secured liberties. It's arguing the Fifth Amendment here, but it's basically arguing against encroachment, all right?